Hello, am I audible? Hello, am I audible? Hello, hello, good afternoon. Hello, 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 hello. Hello, am I audible? My, am I audible from my side? Shall I start the class? Hello, 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 hello. Well, in today's class, we will be studying about the introduction of company and companies law. So basically, first of all, we'll start with the company law thing, right? So we need to understand the meaning of company law, right? So I'll be describing about the definition of company law first. Well, the expression company law may be defined as a branch of law governing the companies, right? So it deals with all the aspects relating to companies, such as you can say incorporation of companies, then allotment of share counts, also share capital membership in companies. Then we have borrowing by companies, management and administration of companies, winding up of companies. So all those things come, these all aspects come under company law. Thus, the company law is that branch of law which exclusively deal with all the matters relating to companies. The company law in India is codified and contained the Companies Act 2013. So this act extends to the whole of India. Whole of India, the same act, which is the Company Act 2013. The whole act is being extended to throughout India. Okay. Also, when we talk about the development of the company law in India, it's originally it's origin to the law of companies as it developed in England. Right. A brief discussion on English system and the development of Indian English law relating to companies become necessary in this regard. That's what I feel. So during the 11th to 13th centuries, the association of merchants called the merchant guilds were prevailed in England in order to secure for their members a monopoly in respect of a particular trade of commodity, you can say. So the merchant guilds obtained a charter from the crown, and each member of the guild traded his own account, right? So that is, you can say, from where the company law has begun and developed, right? Now, next we'll talk about objects of company law. That is also necessary when we are starting and we are knowing about company, we need to understand the object of company law first. Yeah, over here I can see Kate Uma has joined. Uma, can you please confirm, is my voice audible?
Yes, ma'am.
Okay, thank you so much. 1 minute, I'll continue. Yeah, continuing to objects of company law. So we have already discussed that the company law in India is codified and now contained in the Companies Act 2030, as I have mentioned earlier. So the object of company law are those with which the Company Act 2013 was passed, and I'll just summarize the objects right over here for you. So the first thing first, under the objects we have to ensure that the activities of the companies are carried on not only in the interest of those directly concerned with them, but also in furtherance of the ultimate ends of our economic and social policy, which the country has accepted. Now, the meaning of this object is key the activities which are being done by the companies that should not be only for the interest of the people who are concerned, but also for our country's economic and social policy, right? So all those things also, the interest of the company is accountable. So that is the first object. Next thing is to fix up minimum standard of business integrity and conduct in the promotion and management of companies affair. So whatever activity is being done, be it the conduct of the promotion and management, whatever it is, there has to be a certain minimum standard that has to be fixed, right? So that is the next object. Next comes to protect the legitimate interest of the shareholder by ensuring effective participation and control by them. Now, in every companies, there are shareholders, or you can say stakeholders as well. So what they're saying is these shareholders and stakeholders should have effective participation in the legitimate interest of the company. Well, next one is to prevent misconduct and malpractices on the part of company management and abuse of power vested in them by the general body of shareholders. So all the misconduct and all the malpractices on the part of company management and abuse of power vested in them by the general body of shareholders, right? Now, the next thing is to enforce proper performance of duties by persons responsible for the management of companies. So that is next. Also to require full and fair disclose to all the reasonable information. So all the information has to be disclosed relating to the affairs of the company. Also to adjust the right of the management, that is shareholders and other concerned principals. So all the right has to be protected by the management of whom? Of the shareholders and the other concerned people. The last object I'll say is about to empower the government to intervene and investigate into the affairs of the company where the business of the company is being carried on in a manner prejudicial to the interest of the shareholders, the company, or the general public, right? That means government has to intervene and investigate whatever matter is they are there. The government has full right to inspect the thing, to investigate the things, and to intervene. So these are the basic, you can say the summarized form of objects of company law. Now I'll talk about incorporations of companies. Well, uh, it deals with the law relating to incorporation of companies and may be studied under these heads. I'll discuss these heads. Right. The first head is the nature and kind of company. Well, the company and its nature is revealed by special characteristics with a company possession. The different kind of companies and the legal provision relating thereto also have been discussed, and I'll be discussing all these things, right? Then we have formation of a company, the second incorporation, also memorandum of association, and last one is article of association. So all those things we will be covering under Unit 1. Now we'll talk about membership in companies. Well, the first one. Yes, I was talking about membership in companies. So the capacity of members and their respective rights, including the voting right and liability, also have been discussed, right? And we have to put together under one title, that is membership of a company. Next thing is borrowing by companies and registration of charge. Well, borrowing can be done. There are two methods. The first one is borrowing power of a company and debentures of a company. Well, in borrowing powers of the company, it basically deal with the legal provision relating to the borrowing powers of the company and the registration of charges created on the assets of company as security for the repayment of the money borrowed. Also, the legal provisions relating to extent of borrowing powers, authorized and unauthorized borrowing, creating of charge has also been done. Also, the next part under borrowing is debentures of company. So a debenture, what is a debenture? It is a certificate of loan issued by the company, which creates or acknowledge an indebtedness of the company, right? Also, there are different kind of debentures along with the legal provision, which we will discuss further. Well, next is management and administration of company. So under management and administration of company, there are certain things which we have to cover or discuss. These things are directors of a company, then managerial personnel of the company, that is the management, or the people who have control or the management powers, right? So those are managerial personnel of a company. Then we have company secretary, meeting and resolutions, dividends, accounts, audits, and investigation, supremacy of majority and protection of minority. Then we have prevention of operation and mismanagement and organization change in a company. Give me a moment. I'll start with the characteristics. Well, next thing is characteristics of a company. Well, the unique feature of a company distinguish it from other form of businesses. So let's discuss one by one what are the different characteristics of a company. The very first one is separate legal entity, which means a company is an independent entity distinct from its shareholders and director. That means it can own property, enter contracts, and sue or be sued in its name, right? Next characteristic is limited liability. By limited liability, we mean the liability of our members is generally limited to the extent of their shareholdings. So this feature protects personal assets from corporate debts. That means company has a limited liability. Next characteristic is perceptual succession. By perceptual succession, we mean the company's existence is not affected by change in any ownership, management, or the death of its member. It continues until legally dissolved. That means if the ownership of the company changes or the management changes or any person in the management dies, that means company is not going to dissolve. In what condition company is going to dissolve? Legally, when it is done legally. That means if the people who are owning the company, running the company, if they are getting changed, getting transfer or dying, whatever situation it is not going to affect the running of the company. The company will be running throughout until it is been dissolved legally, right? So that is the meaning of term perceptual succession, right? Next characteristic is common seal. Well, historically, when we see a common seal served as the official signature of the company, while it uses is now optional in many jurisdictions, it remains a symbolic representation of corporate authority. So that is company seal. Okay. Next characteristic is transferability of shares. Well, in public companies, share can be freely transferred, allowing liquidity and investment flexibility. So share can be transferred. Next characteristic is capacity to sue and be sued. That means a company can initiate legal proceeding or defend itself in its own name. So that is, it can be sued or it can sue other companies, right? Well, next is separation of ownership and management. Well, shareholders own the company while directors manage its day-to-day affairs, ensuring professional governance. Next, under this, we have artificial legal person. Well, a company is regarded as an artificial person, meaning it is created by law and does not have any physical existence. However, it can perform actions like a natural person, such as entering into contract and owning assets. The last characteristics which I'll discuss is about raising a capital. Well, a company can raise capital through the equity, that is shares, debts, that is loans, or other financial instruments. This ability to pool funds from diverse sources is a key advantage. Now, next thing, which is very important from this unit is about company and partnership. You can see on the PPT, the fourth point, that is company and partnership. Well, a company and a partnership are both form a business organization, but they differ significantly in structure, liability, and governance. Well, when we talk about the aspect, the very first aspect is legal status. So company has a separate legal status, whereas partnership do not have any separate legal entity. Next is liability. Liability is limited to share held and partnership is unlimited. Next thing is ownership. So a company ownership transfer. Well, the shares are transferable when we talk about company, but when we talk about partnership, the consent of all the partners are required for any transfer. Next aspect is registration. So mandatory, it is very mandatory under the Companies Act, but when we talk about partnership, it is not at all mandatory. Next one is management. So the directors govern the company. Well, and we talk about partnership. The partnership manage the business. Now, the next aspect is continuity. So continuity is about perceptual succession when we talk about in terms of company. And for partnership, it dissolve upon death of a partner, unless otherwise agreed, right? So the distinct highlights the sustainability of companies for larger ventures, while partnership often cater to small or closely held businesses, right? Now, in our unit, the next topic over here is kinds of companies, right? So we'll discuss one by one about the kinds of companies. The very first kind is based on incorporation, right? The very first under incorporation we have is statutory companies. By statutory companies, we mean it is formed by a special act of parliament or legislature, right? The example could be Reserve Bank of India under statutory company. Okay. Next one is registered company. So a registered company is incorporated under the Companies Act. Okay. Not required by the special act of parliament. That is for statutory, right? And for a registered, only incorporated under the Companies Act. So that is the first kind of a company based on incorporation. I hope I'm clear. Next one is based on liability. Well, the first under this we have companies limited by share. That is, members' liability is limited to the unpaid amount on their shares. Then we have companies limited by guarantee. That is, members' liability is limited to the amount they agree to contribute in case of liquidation. Then we have unlimited companies. Well, members have unlimited liability for the company's debt. So these are the three under the category of liability. What three companies? Companies limited by shares, companies limited by guarantee, and unlimited companies under liability. Okay. Next one we have based on membership. Well, under membership, the first one is private companies. We all know about them. That is, it is restrict share transferred and limited to 200 members only. That is a private company. Next is public company. So shares are freely transferable and available to the public. Then we have third category, which is known as OPC. OPC is one person company. It is owned by a single individual introduced to promote entrepreneurship. So we have under membership, private company, public company, and OPC. That is one person company. Next kind of company we have based on control. Well, under this we have holding company. So by holding company, we mean a company that controls one or more subsidiary company. And what is a subsidiary company? A subsidiary company controlled by a holding company. So that is based on control, two types. What are those? Holding company and subsidiary companies. Next kind of companies are based on purpose. So the first purpose is for profit companies. that is formed to generate profits for shareholders, and non-profit companies that is established for charitable, social, or education purposes. Example could be Section 8 companies in India, right? So these are the kind of companies, I'll repeat again, based on incorporation, based on liability, based on membership, based on control, based on purpose. Five kinds of companies. So this is quite important point from this unit. Kind of companies. Don't leave this topic from examination point of view, right? Now, are you people listening? Anybody can unmute and talk to me? Hello? Hello? Hello?
Yes, ma'am, listening.
Yes, Anjali. Anjali, I have a
Yes, ma'am.
question for you. Can you please tell me what sources you have to study this subject? What material you people are having?
Textbooks, ma'am.
Textbooks provided by university, right?
Yes, ma'am.
Okay, those textbooks are very nice and sufficient enough for your examination point of view, I'll say. So I'll be explaining all the units under your syllabus. If at all you feel any topic need to be covered, especially, please let me know before completion of the classes any day, right? I am sending my email address in the chat box. If you want to communicate to me, you can always send me an email. Whatever queries you have, any extra notes you want, right? Regarding any particular topic, not the whole, right? So you can see my email address in the chat box. Yes, no. Yeah. So I was saying, for any queries, any help, any extra notes, any extra class, any extra explanation of any topic, please send me an email before completion of the classes, so that in the last two classes, I'll be explaining or handling your queries, whatever problem, whatever things you people want me to explain. Yes? Yes, no?
Clear, ma'am.
Great. Now, please give me a 2 minute. We will start our next topic, that is corporate week. Just give me 2 minutes now. Okay, yes. So, in the unit, the next topic we have is corporate veil. VEIL, corporate veil. Well, the corporate veil refers to the legal separation between the companies and the members. So, you know how a company is being made? Company is being made by the members, right? So when these members are being separated, that is known as corporate veil. So this doctrine helps shareholder from personal liability of the company's debts and obligations. It allows individuals to engage in business ventures and reduce personal risk. Next thing is lifting of corporate wheel. So, in certain circumstances, court may disregard the separate legal personality of a company to hold its member or directors personally liable. This is known as lifting the corporate wheel. So, what are the circumstances we will study? The first circumstance is fraud or improper conduct. It means when a company is used as a vehicle for fraudulent activity, the court may pierce the corporate wheel to identify and penalize the individual responsible. That is the first circumstance, that is fraud or improper conduct. Next circumstance is tax evasion. That means do not submit the tax properly or on time. That is, if a company is formed to evade taxes, authorities may lift the wheel to ascertain the true financial transactions. Okay. Next is agency relationship. Well, when a company acts as an agent for its shareholders, the corporate wheel may be ignored to attribute liability of the principals. Next, we have public interest. Well, in cases where public welfare or state security is at stake, court may disregard the corporate weal. So that is the fourth circumstance, that is public interest. Next one is improper conduct in group companies. Well, in cases where holding and subsidiary companies are structured to deceive stakeholders or creditors, the court may look beyond the corporate structure. So these are the basic five circumstances or situation under which the corporate wheel is being lifted. These situations are fraud or improper conduct, tax evasion, agency relationship, public interest, improper conduct in group companies. Hello. Anybody want to speak? Hello. Yeah. Now we'll talk about the exceptions. That is when the corporate wheel is lifted. कौन कौन सी situation में ऐसा नहीं होगा. So while the corporate wheel doctrine is fundamental, exceptions exist to prevent misuse. The first one is statutory provision. So under statutory provisions, we have non-compliance with statutory obligations such as tax evasion or false statement during incorporation. Then we have default in payment of dividend or debts. Next, we have fraudulent and improper conduct. That is company created for fraudulent purposes and also diversion of funds for personal benefit. Then the third exception is group enterprise. So in this group enterprise, in holdings and subsidiary companies, the wheel may be lifted to understand the actual control and the liabilities of the company. So that is group enterprise. Okay. Next, we have enemy characteristics. Well, during, let's say, take example of wartime or national emergencies, companies suspect of different affiliations may lose their protection under the corporate wheel. Then we have avoidance of welfare law. So when a company is formed to avoid legal obligations, such as labor or environmental laws. So under this, what a company is doing, they are avoiding the welfare laws, right? So under all these exceptions, the corporate wheel is lifted. What are these? That is statutory provision, fraudulent and improper conduct, group enterprises, enemy character, and avoidance of welfare laws. Okay. Now, all in all, regarding company, what I'll say is the concept of company plays a very crucial role in modern business. offering benefits like limited liability, perceptual succession, and ease of resource mobilization. However, the misuse of corporate privileges necessitate mechanism like lifting the corporate wheel to ensure accountability, a clear understanding of the meaning, characteristics, and type of companies, along with the doctrine of corporate wheel. It equips individual to navigate the complexities of corporate law effectively. As business practice evolve, these principles remain essential for maintaining a balance between innovation, enterprise, and legal responsibility. Okay, so that was about Unit 1 company. I have summarized the whole unit for you, right? Next, we shall move to the second unit, that is Unit 2 incorporation. Just give me a moment. I'll be starting the unit in a minute. Yeah. So regarding incorporation, first of all, we need to understand the procedure of incorporation. Well, incorporation refers to the legal process uh, through which a company entry becomes a corporation recognized under the law. Well, the procedure of incorporation involves several steps and varies slightly
Hello.
depending on the jurisdiction. Below, now we'll discuss about the process of incorporation, right? The very first step
Hello, ma'am.
process is choosing the type of company. That means the promoter must decide on the type of company they want to incorporate, such as
Hello,
a
ma'am.
private company or a public limited company or a one-person company, which we have discussed in the unit 1, right? So each type has distinct legal and operational implications. So you need to choose the type of company, the first step. The second one is selecting a name. Selecting a name. So a unique name for the company is chosen and submitted for approval to the appropriate authority. Who are the appropriate authorities? It could be registrar of companies known as ROC. Also, the name should not conflict with existing businesses or trademarks. You cannot use the name of a company which is already existing. So that is one provision under this. Next is draft. Third step is drafting of documents. Well, key legal documents such as MOA, that is Memorandum of Association, and AOA, Articles of Associations, are prepared. These documents define the company's, what do they define? The company's objectives, the rules, and also the procedures of internal governance. Next, we have application for digital signature certificate, which is DSC. Directors and other key stakeholders need digital signatures to authenticate electronic documents filled with government authorities. Give me a minute, please. So we were at the steps, right? So we have discussed about the application for digital signatures certificates, which is known as DSC. Well, the directors and other key stakeholders need digital signatures to authenticate electronic documents filled with government authorities. So DSC, that is digital signatures are required, mandatory, right? Next is filling of incorporation documents. That is the incorporation application along with memorandum of association and articles of association and other supporting documents such as you can say ID proofs, address proof, affidavits that has to be filed with the ROC, that is the registrar or the relevant authority for filing. Okay. So after filing, the next step is payment of fee and stamp duty. The payment has to be made. So for payment, the requisite fee and stamp duties based on the authorized capital of the company are paid during the submission of the document. So along with submission of the documents, whatever the fee required for that formation of the company have to be paid alongside. Okay. Next comes verification by registrar. Hello, anybody speaking? Anybody need to ask anything?
Yes, ma'am.
Yeah, please tell me, Anjali.
What is mean by incorporation, ma'am?
Incorporation is basically, it refers to the legal process through which a business entity becomes a corporation, right? When a business becomes a corporation, that procedure is known as procedure of incorporation, right?
One
It is
business
a
or various business, ma'am?
it is a legal process. Incorporation is a legal process through which a business becomes a corporation, recognized under the law.
Yes.
Got it?
Yes, ma'am.
Yeah. When a business becomes corporation, it has to go through a legal procedure. That legal procedure is known as incorporation. So we are discussing about the steps of incorporation only now, right? That is choosing the type of company. Then we are selecting the name of the company, drafting the documents, application of digital signatures, then filing of the documents, payment of fees. Yeah, till here we have discussed, right, Anjali?
Yes, ma'am.
Yeah, next, the seventh one is verification. After this comes the verification by registrar. So the registrar examine the submitted documents to ensure compliance with legal requirements. So all documents are cross-checked and through legal compliance, are they there or not? They check that and then they approve it. Then after approval, what they'll do, the last step is issuance of certificate of incorporation. So that is once all documents are met, the registrar issue a certificate of incorporation, marking the company as a legally recognized entity. Got, got it?
Yeah, ma'am.
Okay. Now the next thing we have is, yeah, certificate of incorporation. Well, the certificate of incorporation is a legal document issued by the registrar of company, ROC, after all incorporation formalities are completed. You get a certificate that is termed as certificate of incorporation. Also, it serves as evidence that company has been duly registered and is recognized as a separate legal entity. So certificate, what does it show? It shows that is the company is duly registered and it is a separate legal entity. ये certificate show करता है. Okay. Now we'll discuss about the key features what this certificate has. Okay. The first feature it says that it is a legal entity. इसका मतलब क्या है? The certificate established the company as a distinct legal entity separate from its owner or promoters. So company will be a company. A person will not represent a company. Company is itself a separate legal entity. Like you are a separate person. myself a separate person. So company will be a separate legal entity, the very first thing. Then details are mentioned. Well, it contains the company Hello, sorry, I got disconnected. There was some. Hello, am I audible? Yeah, sorry, I got disconnected. I had some network issue from my end. Yeah. So the next topic is conclusiveness of certificate of incorporation. So let's discuss about conclusiveness. Well, the conclusiveness of certificate of incorporation implies that once the certificate is issued, the existence of the company cannot be disputed. It will be there, right? Courts and stakeholders must accept it as conclusive evidence that all legal requirements for incorporations were fulfilled. Okay. Now, what are the legal implications? You'll ask. Under this, we have protection from stakeholders. Well, it ensured that third party can rely on the legal standing of the company. Also, even if there are procedural irregularities during incorporation, the certificate serves as final proof of the company existence. Okay, so that is very important, the certificate of incorporation. Next legal implication under this is binding effect. Well, the company can now sue or be sued in its corporate name and its own property. Exceptions such as fraudulent misrepresentation during incorporation. It may allow courts to question the validity of incorporation. Okay, so these are the legal implications of certificate of incorporations. Next topic under Unit 2, we have promoters, right? So, who are promoters? These are the individuals or entities who conceive the idea of forming a company and take necessary steps to bring it into existence. There are instruments in laying the foundation for the company. Right. Now we'll discuss about the roles of the promoters. The very first role is idea generation. Well, identifying a viable business opportunity and defining the objectives of the company. So that is the first, you can say, role of promoter, that is idea generation. Next role is organizing resources. Well, securing financial, human, and legal resources required for the incorporation is the sole role of promoters. Next, the third role is drafting key document, that is for assisting in the preparation of memorandum of association and article of association. Well, these two topics, memorandum of association and AOA, article of association, we will discuss further in further classes. Next, the fourth, you can say, role is ensuring compliance. That means everything is under law, working under law, and no fraudulent activities taking place, right? So ensuring adherence to legal formalities and liaising with the registrar. Okay. Next one is identifying directors. So recruiting capable individual to serve as a company director. These are the basic roles of promoters. I'll repeat again. First is the idea generation, then organizing resources, then drafting key documents, ensuring compliance, and identifying directors. Okay. Also, we'll talk about the responsibilities of promoters. The first responsibility is like acting in the best interest of the company and avoiding conflict of interest. Next responsibility is revealing any profit earned through the promotion process. Also, assuming personal liability of contract entered into on behalf of the company before incorporation. So these are the basic responsibilities of promoters. Anybody need to ask about anything?
All the employees are promoters, ma'am.
No, all the employees are not promoters. Promoter are basically who give the idea or who conceive the idea of forming a company, right? And the person who take responsibility in the formation of the company are termed as promoters. Employees does not come under the category of promoter. Basically, these are the basic people or the, you can say, the people who are responsible in laying the foundation stone for the company. These people are promoters. Got it?
Yes, ma'am.
Okay. Now, the last topic is pre-incorporation contracts. Well, pre-incorporation contracts are agreements entered into by promoters on behalf of a company. So, on behalf of a company, when promoters enter into a contract before it is formally incorporated. कंपनी फॉर्म होने से पहले, इनकॉर्पोरेशन बनने से पहले जो प्रोमोटर्स लीगल कॉन्ट्रैक्ट करते हैं on behalf of company, that is known as pre-incorporation contracts. So these contracts are necessary for activities such as leasing premises, जहाँ पे the company will work, then hiring employees or purchasing equipments. So for all these activities, contract need to be done. So ये जो सारी activities होंगे, ये सारी एक्टिविटीज करना पड़ते हैं बिफोर द फॉर्मेशन ऑफ द कंपनी. So before the formation of the company, when we enter into a contract, those contracts are termed as pre-incorporation contracts. And basically, promoters enter on behalf of company in these contracts. Okay, I hope I'm clear. Now, all in all, there are certain risks associated with pre-incorporation contracts. These risks could be promoters' financial exposure. Well, promoters may be held liable if the company fails to adopt the contract, and third-party concern are also there, like Other party may hesitate to enter agreements and without insurance of company's ratification. All in all, the incorporation of a company is a very meticulous process involving several legal and procedural steps. Promoters play a very important role in this phase, ensuring compliance and laying the groundwork for the company's operation. The certificate of incorporation is the ultimate proof of company's legal existence. Okay. And the conclusiveness protects about the company and its stakeholders. Pre-incorporation contracts, though essentially for it is essential for operational readiness, requires careful handling to mitigate tasks. Together, these elements form a foundation for a smooth functioning of a corporate entity. Right. So this was all about incorporation. I hope I'm clear. Next is, yeah, next we'll discuss next, I mean, the next class tomorrow, same time, 1:30, we'll meet and discuss about it. Still, we have few minutes in our class. If you have any question, you can ask me.